Vice President.
Minister of Trade and Industry, you have 16 more minutes.
Thank you very much, Mr. Deputy President, Mr. Vice President, and I do apologize. I've gone to the restroom. And if I can just recap, I gave support to the Honourable AG on the introduction of this package of land bills. And I would have addressed particular areas in the bill, which, in particular, the question of the role of the registrar. I had gone on to ease the concern of Senator Mark when he spoke about the question, when he made issue with the fact that persons would no longer be able to pay their money and do their searches, and had cleared that up, and that persons can in fact do their electronic searches, but it is where it involves the physical documents that the work of the attorney, an attorney at law, or a search clerk would be involved, in that they would have to in fact do the searches, and the reason being to cure the mischief, which is that in many cases the actual physical records are tampered with. I went on, Mr. Vice President, to speak about our overall concern with regard to where we are in terms of land registration. I spoke about the indices, the ease of doing business, the Global Competitive Index, and in particular, what the Ministry of Trade is doing, and indeed all the other ministries are doing with regard to our reforms. Specifically, I addressed the question of the reform of registering property and highlighted the deliverables, some of which have already been completed by the Office of the Attorney General. I then went on to raise to speak to some of the difficulties we've had throughout the system on account of the very archaic and very cumbersome land registration system, justifying the need for the introduction of this proper, fulsome land administration system. And I had cited particular areas with regard to the HDC, and in cases of compulsory acquisition, where there would be difficulty in completing the transactions on account of the very bureaucratic systems. And I think I was at the point where I was about to cite an example of an investment which is hampered by the very bureaucratic system. And Senator Mark did, in fact, raise the question of the facilitation of investments. And yes, I would agree that the facilitation of investments is, in fact, stymied by the poor land administration system. And I can tell you that as Minister of Trade and Industry, I have had to get my hands wet. And what Cabinet has, in fact, approved is an investment facilitation framework where it allows me as Minister of Trade and Industry to sit with all of the professionals and the professional staff in the public service and from the various areas. I'm talking about the EME, and I'm talking about the Commissioner of State Lands, and also the Town and Country Planning, as a means of facilitating foreign direct investment. These are land issues. And if we don't take that approach until the reforms come into place, you would find that these investments would take years, or we may reach the point where the investor would be turned away. And hence the reason why we've had to fast track. And it makes a difference. I am dealing with a particular investment at this time, and in under 60 days, I have been able, with the cooperation of the public servants, to facilitate the entire land process. But again, that's by dealing with it hands-on. That's not what we want. What we want is a proper system and framework, and this package of land legislation is a step and a part of fixing and this whole system and facilitating investment flows. And there was a general conversation earlier about sustainable development and the attainment of this SDGs, as pet subject by Senator Mark. I think that's the motion that he had brought to the House, and the first motion, and he was successful, and we supported that motion. And I couldn't agree with him more. But at the base of the attainment of your sustainable development goals is economic development. Without economic development, there is no way that and I'm sure Senator Mark will agree with me, there's no way you can attain your SDGs. But I can tell you, a lot of it has to do with investments, and therefore you come right back to a proper land administration system. So all that you're speaking of, financial development, economic development, SDGs, a lot of it comes right back to fixing your whole question of land administration. And in the course of my of preparation for today, I looked at an article called and allow me to go to it, Financial Development, Property Rights and Growth. Authors being, I think they must be Dutch, Kleesens and Luc Leven. It's in the Journal of Finance, 2003, and I cite, in countries with more secure property rights, firms might allocate resources better and consequently grow faster as the returns on different types of assets are more protected against competitors' actions. Using data on sectoral value added for a large number of countries, we find evidence consistent with better property rights leading to higher growth through improved asset allocation. Quantitatively, the growth effect is as large as that of improved access to financing due to greater financial development. Our results are robust, using various samples and specifications, including controlling our growth opportunities. And I bring this to light to show the correlation between property rights and a proper land administration system to financial growth, economic growth, and therefore attainment of the SDGs. I mean to say that, therefore, we fix the system, the work of InvestTT becomes a lot better. The work of ETEC, who are in effect land administrators, they're the ones who hold the body of lands for businesses, for commercial activity, and their work becomes simplified. ETEC's work is stymied because, again, of the cumbersome system. And so, as I said, it makes the work of the government much easier. Local investors, foreign investors are more willing to engage and to invest, and because there's more certainty with regard to property and land registration and so on. There's predictability for the businessman in doing business, in taking the initiative to do that plunge, for the foreign businessman in attracting him to our country. So there's this whole string of land tenure and ownership related bills are very, very important for economic development. So what I say all of this to say that this legislation has far-reaching effects, and it is vital to our economy. We speak of diversification. It is vital to diversification and attaining all of our goals. In closing, I want to say that the legislation is of national benefit. And so, Senator Mark, when you spoke about social benefits and economic benefits and so on, this little package is a start towards national benefit from using secured land tenure and property and so on, having property rights. And the AG is the one who would have spoken about who would have tied this also to the whole question of identification of the proceeds of crime, including money laundering and corruption, general criminality, and so on. He spoke. He may have mentioned following the money, and therefore this all ties in with the government's anti-corruption agenda. So, in concluding, I want to say at the end of the day, we're going to have a more modernized system, a more efficient system, a legitimate system of land administration. And I even went to, and in fact,
Senator,
what I'm saying.
Minister, you have 5 minutes.
Yeah, thank you. This is an exercise. At the end of the day, the entire population of Trinidad and Tobago will benefit. We have introduced in the legislation evidence-based, cost-effective, common-sense policies, which at the end of the day, we will all benefit from. I want to give my 100% support to the Attorney General in what he has presented to us today. Thank you very much.
Senator Hussain.
Thank you very much, Mr. Vice President, for recognizing me to join this debate on an act to amend the Registration of Titles to Land Act 2000. And Mr. Vice President, this piece of legislation that we are debating here, this bill, consists of 23 clauses that amends the parent act, the Registration of Titles to Land Act 2000. And Mr. Vice President, this is one of the most important pieces of legislation that this Parliament will ever pass in the history of Trinidad and Tobago. And I say this because land is a scarce commodity in this country. We are only a dot on the map, Mr. Vice President. Trinidad and Tobago is approximately 5,128 square kilometers. So therefore, whatever we pass in this Senate with regards to any bill touching and concerning land, we must do it very carefully, and we must study it and give it enough consideration in order for persons to properly regulate their titles in Trinidad and Tobago. And Mr. Vice President, I would like to thank the Minister Paula Gopi-Schoon, Senator the Honorable Paula Gopi-Schoon, for reading the bill for us first of all, and also she indicated that the UNC did nothing with regards to land reform in Trinidad and Tobago. But I want to rebut that statement by simply saying that while the People's Partnership Government, under the leadership of Kamala Persad-Bissessar, we passed an act called the Planning and Facilitation of Development Act 2014. Mr. Vice President, what that act does is revolutionize the entire planning and urban development of Trinidad and Tobago. It was laying the foundation, it was laying the framework in order for a proper land use policy in this country. And there was also the National Spatial Development Strategy for Trinidad and Tobago. So what we started to do was we started to creep before we could walk or before we could run, Mr. Vice President. And that is a responsible government because we are dealing with land, one of the scarcest commodity in this country.
We're getting hyper.
And Mr. Vice President, what this bill does, it changes the system of land in Trinidad and Tobago. The Attorney General, during his piloting of this bill, indicated that there are currently two systems of land in Trinidad and Tobago. The first being the common law system, or we refer to it also as the unregistered system. And then we have the RPO system, which is the real property act system. The ordinance is now an act, yes. And Mr. Vice President, what this bill does is something very similar to what currently exists in the Real Property Act system, which is to have land certificates or certificates of title being endorsed at the back of them and having duplicate copies. One, the owner retains one, and one is lodged in the registry. So it shows certainty of title. It brings in indefeasibility of title. And this is the principles as outlined in the Torrent system, which has its genesis in Australia. And there are three principles coming out from the Torrent system, Mr. Vice President. The first being the mirror principle, which I just explained, that there would be two duplicate land certificates or certificates of title, one retained by the owner, one kept in the land registry. Then there's something called the curtain principle. And the curtain principle is what we refer to as the indefeasibility of title, which when someone passes title through the land certificates, it would mean that their title is good title. It is good and marketable title, Mr. Vice President. And then the third principle coming out of this is the assurance principle, because the state in this case guarantees good title. So therefore, if bad title passes, the state would be the body to compensate the person who has suffered loss. And I say this because that provision is actually included in the parent bill, Mr. Vice President. So as I go directly into the clauses of the bill, and I would start at clause 15, which refers to the principle dealing with the indefeasibility of title of these lands that fall under what will now fall under the Registration of Titles to Land Act. And when we look at the prerequisites in order to register land under this act, Mr. Vice President, Section 19, subsection 4 of the Parent Act, if you would allow me to quote, that with every land certificate that has to be registered into the registry, it must be accompanied by a map or a plan that is actually approved by the Director of Surveys. But Mr. Vice President, I don't know if you know, but in order to get currently any map or any survey approved by the Director of Surveys, it takes sometimes 6 to 8 months. I have colleagues that their plans are there for over 1 year, Mr. Vice President. So this determines the length of time a person will have to take in order to register their land certificates. And this is dealing specifically with respect to subdivisions under the new system. And when you have to subdivide a larger portion of land, Mr. Vice President, because the older generation, they would have bought large parcels of land, and now they would want to subdivide the land so that they could pass it on to their children, their grandchildren, maybe their spouse. But in order for them to do this, first they need town and country approval. And I was made to understand, I had a conversation with a surveyor recently before we debated this bill, and he was indicating to me that town and country now requires that you actually construct a road in the land in order to get town and country approval. And Mr. Vice President, that is extremely expensive in order for that infrastructure and that development, Mr. Vice President. Then you need local health approval. Then you need county medical officer of health approval. You need TNTEC approval, WASA approval. And Mr. Vice President, I say all of this to show how difficult it would be now under the system for us to deal with lands under the registration of title. These are the realities that we face as practitioners, as owners of land in this country. And in order for this bill to actually be operationalized in Trinidad and Tobago, what we need to do is actually fix the system first. We should fix the Town and Country Department, Planning Division, because we need more staff in order to process more applications that come towards them for approvals under the new bill. We need more staff at the Director of Surveys. Because, Mr. Vice President, when you look at what happens at the Director of Surveys office, his office is actually located on Wrightson Road in the General Post Office. And I have received from certain colleagues also information that that building was earmarked for destruction. So, Mr. Vice President, we have a situation where we need to develop the infrastructure surrounding this bill in order for it to actually be operationalized properly, so that when we have the system come on board, that we don't have complaints of inordinate delays in order to get our land certificates registered at the land registry. And I looked at the draft estimates of developmental program expenditure 2018, head 23, sub-item 18, Mr. Vice President, and it's entitled Strengthened Information Management of the Registrar General's Department. In 2016, Mr. Vice President, there was no expenditure. In 2017, the estimate was $15 million. The revised estimate for 2017 was $2.5 million. The estimate for 2018 is $13 million. Mr. Vice President, if we are serious about changing the land system in this country, we need to do more than that. This entails a comprehensive reform of the land registry system as it stands. And 2.5, knowing that you are going to bring this bill to this House, you cannot just only spend $2.5 million to fix that registry, Mr. Vice President. More must be done, more infrastructure. So what I would like the Attorney General to address in the winding up is basically, when we pass this piece of legislation in this House, when will this become law? When will it be proclaimed? Because the 2000 Act is on the law books, but it has not been proclaimed. It has been assented to, but 18 years, and it has not been proclaimed. So is it that we are going to pass this bill and allow it to lay in abeyance also, Mr. Vice President? So these are certain issues that I would like to raise, because we need to operate with some sort of certainty, because when I sit in my office and I advise my clients with respect to land transactions, I must have some certainty as to when this land system is going to change. How am I to advise them? How are they to conduct their business in the future? Because buying land is not buying sweetie in a parlor. Buying land is a life investment. It is an investment that will pass on to your generation as you go along, Mr. Vice President. So we must operate with some sort of certainty. And I'm sure once we have this level of certainty in this country, it will actually encourage growth with respect to our economy. That will, I know the Minister of Finance would have indicated that we have a turnaround, but we might want a bigger turnaround now once we get our land tenure system in place, Mr. Vice President. Senator Mark raised this point with regards to the establishment of the Senior Assistant Registrar. When I looked at Section 6 of the Parent Act, it gave the qualifications of the Senior Assistant Registrar. And when we read the bill together with the Parent Act, it would read that no person shall be appointed as an Assistant Registrar or Senior Assistant Registrar unless he's an attorney at law. What this means, Mr. Vice President, is that you don't need any experience whatsoever to become a Senior Assistant Registrar under this bill. What you need is that you go to Hewarding, or you do the external program through London, and you are called to the bar, and then you get a job as a Senior Assistant Registrar. So I'm asking whether or not we should include a level of experience with regards to this position, because this person can perform a quasi-judicial function, because in the absence of the substantive registrar, Section 35 of the Parent Act gives a whole host of various functions this person can actually carry out, amending or rectifying land certificates, the folios, Mr. Vice President. So these are very important functions that this person has to execute in their duties. Also, with respect to the salary and the job description, I don't know if the Attorney General would address all of this in the winding up because I didn't hear it in the piloting of the bill. And when I looked at the Hansard in 2000, when this bill was being debated in the House of Representatives, the current Prime Minister, Dr. Keith Rowley, member for Diego Martin West, he raised certain concerns with regards to this post because he was saying that why should it only be restricted to an attorney at law? Why not someone who has vast experience in land management system? Because he believed at that time that those persons might be better able to carry out the duties of a registrar rather than an attorney at law because of their vast experience with regards and their background with regards to land management system. So I don't know if the Prime Minister had any input with regards to the bill that was brought before us. Earlier on, I touched on the powers of the registrar, and those are found at Clause 14 of the bill and Section 35 of the Parent Act, Section 34, sorry, of the Parent Act, Mr. Vice President. And when I looked at the bill, there was one concern with regards to the functions that the registrar has, and that is, if you would allow me to read Clause 14, whereupon resurvey, an area shown in the register is found to be incorrect. But in such case, the registrar shall first give notice to all persons appearing by the register to be interested or affected of his intention to rectify. Now, Mr. Vice President, one of the most common claims that are filed in the High Court is one of issues of boundary, and I think the Attorney General, he can attest to that there's always boundary disputes. And in this case, when you have your neighbor saying that, listen, your land isn't, your building is encroaching in my land, or a fence is encroaching on my land, what we normally do is that we will file an application to the court, or file a claim to the court, sorry, and then the court will be the person to resolve this dispute through a trial or probably through some sort of settlement. So I'm asking whether or why we are giving such vast powers to the registrar, in this case, in terms of actually rectifying boundary issues, Mr. Vice President. So I hope those concerns are addressed. The other issue I want to join with Senator Markin is that of the searches. And these searches that are conducted at the Registrar General's office. And now those searches are restricted to an attorney at law or his clerk. Now, his clerk is very vague. Is it that I am to understand that the clerk means the law clerk, the clerk means the search clerk? Because as attorneys at law, we retain search clerks at the Registrar General's office to conduct title searches on the unregistered system so that we would determine whether or not there's a proper root of title or whether or not the chain of title is broken in order to grant any purchaser good and marketable title. So I'm saying that we should not restrict the public from going into the land registry and viewing deeds. Because deeds, list pendants, judgments, bill of sales, power of attorney, all of the deed polls, all of those documents are public documents, Mr. Vice President. And if there's a fear that there might be some security issue, we have been functioning like this for the past how many years since we gained independence, Mr. Vice President? And it is about time that we digitize the system so that we always have a backup copy, or we make physical photocopies and keep it lodged in a vault. So that if somebody decides to tear a page, you know you have a backup copy, digitized and also physical, Mr. Vice President. But we should not at all restrict members of the public from viewing public documents in any government ministry in this country. That is extremely dangerous, Mr. Vice President. With regards to the issue that I know the Attorney General will rebut that point in terms of, well, no, the public has an opportunity to view deeds through an online system. But during the lunch break, I sat behind my computer and I tried to log on to the PIMS online, and it wasn't working. So, Mr. Vice President, imagine a situation like that, I need a search today and the online system isn't working, that means that the public has no access whatsoever to deeds in this country because they are now dependent on an online platform. And we cannot do that, Mr. Vice President. We simply cannot do that because when we do this, there will be hundreds of persons in this country who would be without jobs. Those search clerks, Mr. Vice President. And not all of the records are digitized and are uploaded online. So there's need when the search clerks reach a certain year, they actually have to go and inspect the physical documents or the physical deeds that were not uploaded yet on the system in order to complete their title search, Mr. Vice President. And one thing I want to ask the Attorney General with respect to the operationalization of the online platform is that, are we now giving the public an opportunity to search the memorials that would be entered into the memorial books, which is the folios? Because those are the most important entries that we can think about with regards to the indefeasibility of title, because we need to know who registered an interest with respect to that land in the as a folio, who has any rights or whatever, be it working rights, mines, minerals. We need to know that so that when we pass land, we would know what reservations that they are subject to, Mr. Vice President. And I also, let me move on to clause 16 of the bill with regards to, which amends section 44 of the Parent Act. And this deals with minors and minors holding land in Trinidad and Tobago. Now, our laws allow for a minor or a child to hold land in Trinidad and Tobago. But I see that the amendment removed from section 44 the words restriction and included the word caveat. For the benefit of the public, I would just like to read the definition of what a restriction is. And a restriction, according to the definition section, means a restriction on the way land may be used or dealt with. So when we look at the section that deals with caveats now, because they replace restriction with caveats, and that is found at section 74 of the Parent Act. And a caveat, Mr. Vice President, is any person who, A, claims any unregisterable interest in land, lease, or charge, B, is entitled to a license, C, has presented a bankruptcy petition against the proprietor of any registered land, lease, or charge, D, is a judgment creditor, or E, has obtained a lis pendens, may lodge a caveat with the registrar forbidding the registration of disposition of the land, lease, or charge concerned and the making of entries affecting the same. So now we are allowing the Registrar General, in this case, according to section 44, to lodge a caveat where a minor is allowed to hold the land. Now, section 74, that does not fall within the categories in which a caveat is to be lodged in the registrar to stop a deed from being registered. So when we put this amendment with regards to the caveat, what we are doing is that we are actually stopping any person from transferring land as long as a minor's name is on the land certificate. But respectfully, Attorney General, if a minor holds land in this country, what we can do is apply to the court, get a guardianship order, and the court can direct how the land is dealt with. But in this case, respectfully, with regard to the caveat, we have to engage the caveat procedure now, which is the warning and all the other procedures in order to lift the caveat.
Thank you so much for giving me. It's a very important point that you've raised. But the independent law which relates to the landholding prescriptions against minors still operates. The caveat procedure is to harmonize simply the process of notification to parties. So respectfully, I don't know if there's still an incongruity in terms of logic or process.
My point with respect to this, Attorney General, is that if we leave the word restriction, then the position would remain as you just stated with regards to just going to the court and getting the guardianship order. So I don't understand why we had removed the word restriction and included caveat. So I think that is something that we can probably consider in more detail with respect at the stage of committee of the whole. Also, when I looked at the bill, there's no definition of minor. So I don't know if we want to change the word minor, include it as child, and use the regular definition that we use, that a person under the age of 18, when we deal with lands under this Registration of Titles Act. And Mr. Vice President, I go back to my point by saying that we are passing very important legislation in this country. And this legislation found itself under a United National Congress government. And I would like to publicly commend former Attorney General Ramesh Lawrence Maharaj for the work that he has done with respect to the land packages to reform the land system in our country. And today, that work is continuing. And I'm happy, and I said this at my last debate, that I'm happy that this government did not shelve away the land package, but that they brought it. That although it was a UNC initiative, that they saw that it was good law, and that we can build on that good law, because at the end of the day, all of us here are temporary, all of us, but the laws here are permanent, Mr. Vice President. And we must make good laws for the governance of the people of Trinidad and Tobago. And we must be more patriotic. We must be more patriotic in this country, because we cannot say that because I am a UNC or you are PNM, I would not support the bill. It is what is best for our country. It is what is best for our citizens of Trinidad and Tobago. Because at the end of the day, after any general election, they are no longer PNM or UNC, but they are citizens of the Republic of Trinidad and Tobago. So, Mr. Vice President, with respect to this bill, there's work to be done. We have 3 more bills to come. I don't want to bridge standing orders with regards to anticipation, but I anticipate the other 3 bills that are yet to come, and I will be making some further submissions with regards to the amendments to these bills. And I thank you very much.
Senator Ramkisoon.
Thank you, Mr. Vice President, for the opportunity to speak today on an act to amend the Registration of Titles to Land Act 2000. And it's not a lot of clauses we are here to debate today that we are amending. So I do not anticipate a lengthy debate today for me. I will be quite short and very much tailored to just about 3 clauses or sections of the bill that I had some queries on. In relation to the piloting of the bill, we did learn a lot more, and we learned some statistics as well as the provisional title, which opened up debate into squatters and where we're at with that. But from reading the various amendments put forward, I personally would like to believe that it was championed on lessons learned from practicing such law, and also from reading about where we are and how we kind of try to get the different ministries to really operate in today's society. So I really believe in it as lessons learned, as opposed to just being mischief or dealing with corruption in our system. I really believe we have been evolving, especially land and land ownership is not something that we can talk easily about. Land is quite a touchy topic in our society. Ownership of land is doubly so, and there's different pieces of legislation that has been laid in the Parliament in this particular sitting that is supposed to be coming to us. I unfortunately thought we were going to do all in one, so I had tailored my debate like that. But no, at 9 o'clock last night, they told me that we're going to take it one at a time. So now I'm stuck here trying to figure out what I can say in this debate and what I can't. And I wouldn't say it is any fault of any senator. If they see the reason in separating the bills, then so be it. That is where we have to respect that the information will be brought forward. So I will respect the decisions and understand that that's why they're keeping us here at longer times, right, Mr. Vice President? But that is unfortunately how I had tailored mine. So I do intend to try to not touch on other areas while I go through my concerns with the, well, not really concerns, but more questions on the registration of titles to Land Act 2000 amendments. And one of the particular issues concerns I had was to deal with Clause 14, which deals with Section 30 of the Parent Act, and that's to do with the registrar may rectify the register or any instrument presented for the registrations in the cases listed. And I noticed that we amended it, that the register may have the option to have informal matters or in the case of errors or omissions not materially affecting the interests or any proprietor. And then B, we went on to the case where in any case or any time with the consent of all persons interested. And later we even went on to how we will rectify of the court or the land tribunal. But what I found that, and I'm not sure what is the reasoning behind it, is why did we take out that the registrar may, on application, cancel the registration of the instrumental document and restore the folio to its former state. So we are not giving the registrar the opportunity to cancel the registration of an instrument or document, or cannot even cancel an entry that has ceased. And this was existing in the Parent Act, where we had specific provisions before us today, where the registrar had the opportunity to cancel or to modify registration that has ceased. And this would be on dealing with Section 30, and it would give the effect, and it even give you the opportunity as well to restore information that was prior there before. So I'm not certain why, because I thought that would have been very point-worthy to keep in terms of Clause 30, that we keep that option for the register to have that option to cancel the registration of the instrumental document and to allow the option, if there's a matter that has ceased, that they have that option to cancel it. So I would like that consideration to be taken on board. In relation to Clause 20, which speaks about addressing or changing Clause or Section 73 of the Parent Act, a lot has been said about this Section 73 already. And I am one of the particular senators who applauds movement to doing things online, for doing searches online, for conducting online searches. I'm always one who champions that. And I thought this was a good move, a good step for the government to welcome this initiative for persons to go online and to search the database to find out about land titles and registration, who owns it and how they go about it. Little did I understand that we were changing the rights, and this is what I was a little unclear of, because when I read the Section 73, it says that an attorney at law who holds or is deemed to hold would have the options that presently exist in the law. But then we added other amendments that says a person may, on making an application in the prescribed form and on paying the prescribed fee, be entitled to a certified copy or any folio or part of the parcel index map or any plan in the registry. And then it went on to say a member of the public may search the electronic copies on what I had just spoken about. So to me, that it sounds like we're having both systems in place where we can allow persons to do searches, both going into the by way of a application form or a registered prescribed form that you fill out, that you request certain information from the ministry, or by means of an online electronic record where members of the public can do a search to find out what is the status of their property or something that is not. But listening to the debate so far, this is not the fact. And that is what I would probably need some clarification on. Because I, too, like Senator Hussein, went to the TT Connect website to look at what is required to do, conduct, or what is someone from the public required to do to conduct a registered land title search. And there are specific steps, because you can't just go and search or feel like you need to search something, you just go. You need to go with intent, and you have to have specific information to conduct a search. So, but what I thought was more interesting is not only what you need to do to conduct a search, but now this information is available online. It's on the Government of the Republic of Trinidad and Tobago website. It's on the, for non-residents and for residents, there's specific measures you can take. And it says, what do I need to conduct a registered land title search? And there is an area where they have what fees you pay, if it's $5 or $10 for a general title. And where do I go to conduct a title search? Land title searches are conducted in the offices of the land register, which is listed, and it's what hours are listed. So, and this is the Ministry of the Attorney General and Legal Affairs. So is it now that we will be repealing this measure to the public based on the amendments? Because this is not what I've gotten from reading the amendments. It makes it seem that we have both options, that we can go into the Ministry of Legal Affairs, the Ministry of Attorney General and Legal Affairs, and make an application through Section 73(2). And as well, you have the option of going through the TT Connect efforts through 73(3). So this is what I would like some clarification. And I think the public really would like to know, because land searches are very important, especially now, Mr. Vice President, especially since we've heard that this is an area where we're trying to reduce corruption. Because I have heard of 3 persons paying down on the same piece of land. And this is happening a lot with these colony lands that are being leased. It is very unfortunate. So we don't want to take away from the public the opportunity to know their rights and have the right of information before they go forward into making such a down payment on their land, because normally it's 10% of the property, and property prices, as we know, are not cheap anymore. They start from $300,000, so 10% of that. And we are trying to make sure we have provisions in the law that protects citizens of this country who are making an investment. So I do want us to ensure that we're getting it right, especially before we get into committee stage when we're looking at Section 73 of the Act before us. I'd also like to speak about another clause which was mentioned in the piloting and is in the bill before us, which is with the condominiums, and that is Section 13 of the Act and Clause 9. And we are inserting a condominium folio in respect of each condominium unit created in accordance with Section 20. Now, I am a bit confused by this, because when we look at Section 20, let me just find it so I make sure and read into the records correctly what is being, what we are being asked to amend today. So when we look at Section 13, we are asking that we insert that phrase in which I just read off. And if you look at the existing Parent Act, C says, and let me just get the beginning. This is to deal with the land register specifically. And the register shall be comprised of, and one of the area is every interest folio created in accordance with Sections 17, 19, and 20. And 20 deals specifically with the registrar shall create a separate folio in respect of each unit and the common property designated by a condominium scheme in accordance with the provisions of the Condominiums Act when it comes into operation, or any act which it may repeal or replace it. So we do have, and the subtitle, the marginal note, is condominiums. So my concern or question here is, why is it that we need to put in another addition? Because now in that same register, the register shall comprise of, it has a provision for the condominium. So why now we including an additional section D to say a condominium folio in respect of every condominium unit created in accordance with section 20, which I just read? Why is it necessary? And the thing is, we have to remember that these provisions are already existing in the law. If they are not being operationalized or practiced, that's a different story. Because we as parliamentarians, or especially senators, we are not enforcers, we are legislators. We have it in the law before us already. There's no need to include it again. And if we are including it because persons are not enforcing it, it is not our issue to deal with today. So I need it to be very clear when we are amending law or we are trying to put things in place for enforcers to understand. It should not be so. With the provision already exists in the Parent Act for condominiums folios to be created as part of the register, then let it be. If it is not being done, that is another issue that ministers need to take up in their different ministries. My other point that I wanted to raise was the dealing with errors in the deeds, which we spoke about again in section 13 of the Act, which is clause 9 of the amendment. And this is a very good provision because we do have issues, unfortunately, with errors that can be subject to a lot of disputes. And that's why a lot of times when land settlements, they ask the parties to come to an agreement outside the courtrooms to make the system or the process go smoother. So I do commend the government for that amendment of the registrar and the registry. I do want us to also remember that it is important when we are speaking about land, and especially state land, the importance of this provisional title, the definition that we have put into this particular bill, of how we consider what is state land and what we are going to give you a provisional title for. I have spoken in another debate about persons building their property on state assets, not state lands, state assets. I don't ever hear politicians addressing these concerns, but as an engineer in the industry, I always ask the question, what if? We have properties that are built over gas lines that are part of the state assets, and they are part of the right-of-way of state lands. And these persons, Mr. Vice President, unfortunately, are not there recently. They are there over years. And I know every minister, especially in public utilities, rural development, and local government, always have concerns when they have to go into these areas to provide services. They have to go with armed reinforcement because it's not an easy access. So when we have amendments we're making to the legislation, we have to understand how is this really going to be operationalized? How are we making these parliamentarians sit here for hours? How is it going to benefit the public at any point in time? Because you should not make a statement that you will be entitled to a provisional title on state lands and you are there at your own risk. Who is going to pay if something happens? When you're driving through forest reserve compounds, there are properties or shacks, as we like to say locally, being constructed at their own risk. And if you give these persons a provisional title or a document that gives them an opportunity to purchase or occupy this land and for their family, it is a big risk for themselves, their health, their family, and also to the company, because if anything goes wrong, it's a reputation hazard that we have to deal with internationally. We have had reports in the public domain, Mr. Vice President, where children were playing on these pipelines and they were covered with oil. Who had to pay the repercussions? The company. So we have to look at these things. We have not been maintaining our right-of-way. That's the company's definite fault. But Senator Wade Mark brought up the issue of using technology such as drones to do their inspection. That can be an avenue to be looked at. Now, we don't ever have to look at the regulations, so we would expect these things to be guides, regulations championed by different ministries to ensure that it happens. I have raised 3 clauses that I thought had big questions that were unclear on how we would really operationalize it and really to ensure that we get it right, because you don't want to change something that's going to impact negatively on the systems that you have presently. And we know the challenges that exist with our present system. We don't want to make it worse. We want to make it better. So, Mr. Vice President, with a very few words today, I thank you for the opportunity to debate this.
Minister of Agriculture, Land and Fisheries.
Thank you, Mr. Vice President. I'm very pleased to join the debate on this bill, an act to amend the registration of titles to Land Act 2000. Mr. Vice President, I've listened to those who have spoken before me. I've taken note. And I think that the general view, and let me say, Mr. Vice President, straight off, as the minister responsible for land in Trinidad and Tobago, I want to say that having interacted with my colleagues here and in the other place, and with people around the country, I think there's a common understanding that the state of land administration in Trinidad and Tobago is highly undesirable. And I counted in this House, for example, 2 former MPs, at least, well, 1 MP today, Lower House MP, 4 candidates, people who sought election, and I suppose everybody who is here is capable of being a candidate seeking election. And whether you are a candidate, an MP, or former MP, at some stage you would have listened to at least one story of immense difficulty in dealing with land, particularly state land. So there is a common agreement amongst politicians for more than 30 years that the state of land administration leaves a lot to be desired. And Mr. Vice President, there is no better way to illustrate than to give you an actual example. And from the moment this came to me in March 2018, March 12, 2018, 4 days before the debate in the other place on the similar bills, I felt that I must share this with my colleagues and the country. And this has a 20-year history. And it must be clearly understood that what we do today on this bill and the others, and what we do thereafter, could have profound impact on the people of this country. On the 28th day of October 1998, Leo Joseph from Diego Martin received a letter from the National Housing Authority. And the opening paragraph, Mr. Vice President, reads as follows. Please be advised that the National Housing Authority has assigned you a parcel of land at lot number 29, Cicada, Blue Basin, Block River Estate, under the Squatter Regularization Program for the purpose of constructing a dwelling house upon the following conditions, and some conditions are listed there. October 1998. Thereafter, Mr. Vice President, in 2002, November 13, 2002, the Land Settlement Agency writes to T&Tech saying, please be advised that the Land Settlement Agency has no objection to the supply of electricity being given to Mr. Leo Joseph of Blue Basin, Diego Martin. This area forms part of the agency's squatter regularization program. So 2 state entities have recognized Mr. Joseph's status. 2 years later, October 20th, 2004, the Land Settlement Agency is writing to the Water and Sewage Authority. Dear Sir, Madam, please be advised that the Land Settlement Agency has no objection to a water supply being given to Leo Joseph of Lot 29, Cicada Blue Basin Block, River Estate, Diego Martin. Madam President, when we were debating the property tax and valuation bills on the property tax, in response to Senator Richards, I made the point that squatters had always been subject to tax after we expanded the definition of owner to include occupier. And I made the point that a lot of people will be surprised to know that squatters do in fact pay property tax in this country. So I make reference, among the many documents I have is a receipt, 29th June 2004, where the District Revenue Office is issuing a receipt to Leo Joseph for land and building taxes in respect of lot number 29, Blue Basin Block, Diego Martin. Land Settlement Agency has issued a receipt to Mr. Joseph to regularize his occupation. And then, Madam President, nothing happened until 2014. And Mr. Joseph receives a letter from Ministry of Housing and Urban Development saying that, and I quote, the Ministry of Housing and Urban Development is pleased to inform you that your application for a home improvement grant has been selected at a random draw conducted on 2nd October 2014. So he's now entitled to receive a home improvement grant. And we are dealing with yet another state agency, the Ministry of Housing and Urban Development. On 18th November 2014, Mr. Joseph writes to the Land Settlement Agency, indicating that we have been advised by the Ministry of Housing and Urban Development that we've been selected for a grant, a home improvement grant. And one of the things we must produce is a document showing that we are entitled to ownership of the parcel of land. And that in turn set in train, Madam President, a series of activities between Mr. Joseph, the Land Settlement Agency, HDC, the Ministry of Housing, and on each instance, Mr. Joseph is being sent to another state agency to get something which says that he is entitled to occupation of this parcel of land. Ultimately, on April 29, 2016, Mr. Joseph received this letter from the Ministry of Housing and Urban Development saying, and I quote, reference is made to your application for the home improvement grant and subsequent assessment interview. We regret to inform you that your application has been denied for the undermentioned reason, and the reason is insufficient document submitted, in particular, failure to establish a right to occupy the land. On March 6, 2018, the widow now, because after all this time, Mr. Joseph died, and his widow, Marva Mendoza, it's a handwritten letter, Madam President, 4 pages, in which she traces the entire history from 1998, when she got this letter from National Housing Authority with a deadline to construct and occupy, for which they have complied. And in 2018, she's saying to me, I've now dealt with NHA, Ministry of Housing, LSA, Commissioner of State Lands, T&Tech, WASA, and I still cannot get something that tells me that I am the person entitled to occupy this parcel of land. And Madam President, this is what I deal with every day as a minister, because all of us have spoken about the administrative and the bureaucracy and so on. But when people go to a government office and cannot find an employee and cannot find services and cannot get information, the final recourse is to the minister. And Madam President, when as a minister, I in turn see somebody writes to the Land Management Division of the ministry 1 letter, and in 2 months' time, that person has a tenancy agreement, town and country approval, an approved survey plan, and a confirmation that they should pay $200 a year, for a parcel of land valued at $750,000 in a built-up urban area. When I put Leo Joseph and Marva Mendoza on one side, and I put Orsonville, Nile Street, Orsonville, 2 months, survey plan approved, town and country approval, tenancy agreement, receipt for first year's rent, then I must do my duty as a minister, Madam President. My duties extend beyond this parliament. Today, I'm here as a senator. But when I go out, I have a responsibility to represent every citizen of this country. And I've taken an oath to do so without fear or favor. And this bill is not just words written on a paper. And an oath of office is not something that you swear on and forget. We stand in the defense, whether we're on this side or that side. We stand in the defense of the public interest. And if there's one interest, if today, in dealing with what is before us, we serve one interest, it is the interest of the deceased Leo Joseph and his widow, Marva Mendoza, 2 citizens of this country who have done no wrong and are entitled, if only by virtue of occupation, that right be done by them.
Well said.
Madam President, land has a peculiar history, and we're not here, and the state of poor administration is not necessarily by accident. Because in having any system of administration, you require planning and you require consistency. And as the Attorney General observed, in a sense, we've gotten here through some inadvertence and all sorts of things, including our failure to implement laws that we pass. And if I would just quickly highlight, in my view, some of the key areas. The first is, as the AG has pointed out, we started off with a very ancient system of land administration, a system in which the king owned the land, and the land was managed by virtue of the edicts of the king. But subsequently, there were 2 very important developments in English law, particularly English legal administration, that to this day beset our administration of land in Trinidad and Tobago. And those 2 developments, Madam President, are first, Lord Keynes's Act in 1858, and secondly, the passage of the Supreme Court of Judicature Act in 1873, and I'll deal first with Lord Keynes's Act. Arising out of that feudal system in which the king held command and ruled by edict, the fact is that the court, the system of justice, recognized only the law. In the case of land, legal title. And Lord Keynes's Act in 1858 was the first step towards recognizing what will eventually grow to be the principles of equity. So pursuant to that 1858 Act, we were able to access reliefs like injunctions and specific performance. But in 1873, the English system went one step further. And instead of having separate courts, where you could go with, on the one hand, one court for a legal claim, and on the other hand, to another court for an equitable claim, the 1863 legislation made all courts courts of law and equity. 1873. The point with that, Madam President, is that what we have inherited, we are in a system of land administration, land law, and the registration of titles where we do not only take cognizance of what is written in a deed or what is written in a certificate of title, but good lawyers take cognizance of other interests which we call equitable interests. In fact, Madam President, as everybody knows here, I am a solicitor. And one of the things I've flagged in terms of the evolution of land law in Trinidad and Tobago is this issue of fusion in 1986, when barristers and solicitors were brought together as attorneys at law, and that in itself had a significant impact on land administration and the proper evolution of the administration of land. But Madam President, it is very important that we understand that I was saying in my very first transaction I was asked to do as a solicitor related to a parcel of land in central Trinidad. And on the Monday in Charlieville, in fact, on the Monday when I wrote up on the weekend my opinion to my boss, Ashmead Ali, on the Monday when I presented him with the file and the beautifully written, typed up memo, he didn't even look at the memo. He looked at me and said, "So what you thought about the land?" And I said to him, I started to read from parts of the memo. I said, "No, what you thought about the land?" And he was quite shocked that I didn't go on the land. And he said to me something then, which I practice up to today, that you have to go on the land. Because what the title will tell you who are the parties to the transaction and give you an outline of the survey plan and so on. And those are the legal matters. You would not see the equitable interest, for example, somebody with a shack. A vendor has established a shack on the land and has been selling for the last 25 years. You would not see an easement across the land with the people. I think it is Senator Crease who talked about access to the back lot. So the villagers have been using that to gain access to a roadway for 20, 25 years and may have gotten rights, in addition to which you would not see encroachments and so on. And those are equitable interests. What you will not see on a title, on a deed, and what you would not see on a certificate of title, and what you would not see registered in the registry, you will see if you actually go and visit the parcel on which you are doing a transaction. And that is important. It is important that we understand that the manner in which our treatment of land has evolved has meant that we are dealing with what is on paper and what is also visible on the land. And in a third category, dealings among family members and so on that you are unaware of. And I'm happy Senator Ramkissoon raised the issue of the Caroni lands, because that is an example of the impossibility, because you're dealing with a country where we are fraudsters, the impossibility of determining how many times somebody has gone around to people and offered a deed for sale. I remember temporary Senator Beg raising the point of not wanting to disclose the deed number on the property tax assessment form, the deed number, and I made the point to him that anybody could access a deed, but it's not like you're going to take up the land and walk away with it. But the point is that people in this country do in fact shop the same parcel of land to different buyers and take down payments and so on. And there is very little that you can do to stop that except through the Trinidad and Tobago Police Service. So that it is important that we understand in dealing with all the bills, all matters relating to land, that it is not merely dealing with the physical title and the record at the registry, but in dealing with a series of interests, some of them which are incapable of registration and will only come to the knowledge of a prudent attorney at law or somebody handling a transaction by virtue of physical examination, inquiries, and understanding the history of a parcel of land. And in the evolution also, very quickly I will say, that the Moyne Commission had an impact. In the Moyne Commission, when the Moyne Commission came to inquire into the condition of workers in Trinidad and Tobago, and they paid attention to the oil workers and the sugar workers in particular, it was the Moyne Commission who made the comment that the oil workers seem to be doing well. The sugar workers need help in terms of the barracks and so on that they were living in. And that gave rise to something called the Sugar Industry Labor Welfare Committee, which is a separate housing arrangement for sugar workers, providing loans to sugar workers funded out of a percentage of the proceeds of the exports of sugar. And thereafter, we had the Slum Clearance Act, which in its effect, in the clearance of slums, led to the displacement of people who were living there, and some of them were never settled in other places, which was supposed to be a part of the land clearance. The Land Tenant Security of Tenure Act, 1981, memorable for all of us. It was extremely controversial, but also had a tremendous impact on land administration in this country, because it created two sets of rights that administratively we were not prepared for. And those two sets of rights is, one, the opportunity to purchase the interest at half the market value, which was difficult to administer and never went well, and the statutory lease, which was part of the entitlement of the secured tenant, which again created many difficulties and is a subject matter of a lot of decisions in the court. Madam President, in dealing with this bill, I think we have already established the two systems of land registration in the country. We have already established the various forms of title, leasehold, freehold, equitable, statutory, and so on. Madam President, I just want to make the point that there are many different ways in which you can acquire title in Trinidad and Tobago. And for each method of acquisition of title, there are complications involved, and in some cases, there are bureaucratic delays involved. And very quickly, I'd say the one that is most familiar to us is, of course, the deeds of conveyance. And some people, Senator Hussain spoke about, in every land transaction, conveyancers, solicitors will tell you, it takes a lot of time because it's not just the drafting of the document, but the number of other state agencies and bureaucracies that you must interact with. So deed of conveyance is one of the most popular ways of acquiring title. Deed of gift, deed of assent. In fact, the deed of assent is one of the most frustrating process, simply because the process of estate administration and dealing with what is left by the deceased person could be a long and tedious exercise, especially when there are caveats. Assignment of leasehold interest, of course. Partition, which partition is something under the partition legislation, which ultimately leads to the title being conveyed onto somebody else. Adverse possession, which is something that is dealt with in another bill in this House, and we will deal with that when we come to that point. Compulsory acquisition, also a very frustrating method of dealing with land, and the most difficult part of compulsory acquisition is the fact that the state takes so long to pay. Through the operation of law, people acquire title, adverse possession, through matrimonial proceedings and through estate proceedings. Through court orders, through matrimonial proceedings, estate proceedings, other litigation. Vesting order, particularly within the state, and my colleague Senator Gopi Skoon spoke about the vesting order as we deal with it in HDC lands. Mortgages, sales, receiverships, auctions. All of those things are ways in which every one is grounded in a piece of legislation, and in carrying out what those various pieces of legislation provide for, we ultimately end up with a means or a method of moving, transferring, conveying title, and all are going to be caught by this particular piece of legislation. Madam President, in relation to the bill itself, I would say there are 23 clauses in this bill, as we've said before, and I would say that this bill does three things. The first is that it makes some corrections, and I think that those are the simplest parts of the bill. Where the bill makes corrections, it might be typographical corrections, and those I will identify as clauses 10, 11, 16, 17, 18, 19, and 20, which makes typographical errors, seeks to correct those things. There are some of those clauses which I can call administrative changes, and those clauses are clause 3, 4, and 5 to 8. Clause 3 introduces certain definitions. Clause 4, as Senator Mark has said, refers to the senior assistant registrar. And then clause 5 to 8 all deals with the insertion of the words senior assistant registrar. So I consider those to be administrative changes. Of course, both Senator Mark and Senator Hussain have raised a substantive issue in relation to the qualifications of that office holder, which the Attorney General will address. And clause 12, I also consider to be administrative because that clause seeks to delete the word certificate of title, which is how we currently refer to the title held under the Real Property Ordinance, and replace it by the current terminology, which is land certificate. There are, Madam President, some clauses in this bill which I consider to create some form or affect some form of legal right, and those are the ones that I want to pay particular attention to. The first one, both the AG and some other speakers have traversed, and Senator Ramkisoon spoke about it, and that is the creation of the folio for the condominiums. And as we know, even though the condominiums have emerged more than 20 years, the laws have not kept pace with the peculiarities of that particular type of real estate holding. And in the Property Tax Act, in the Valuation Amendment Bill, we have addressed those. And in this bill, the Attorney General proposes through Clause 9 to allow for a folio to be created specifically for matters relating to registration of title for condominiums. And I don't think anybody could seriously have an issue with that. It represents consistency with previous pieces of legislation that we've worked with. Clause 10, Madam President, I think it's seemingly innocuous, but it does something that is very important in the way in which it makes a slight but important change to the law. And what Clause 10 says is that it makes it clear that the legal interest in a parcel of land is not created by the registration of an instrument, but by the notification of that interest by the registrar with the registrar's certificate. And that may affect, Madam President, it seems to be simple, but that may affect things like priority in terms of registration of mortgages, priority interest. It may impact things like the timing of the registration of a caveat and the way in which it affects, whether it's a registration or a restriction, the way in which it affects priorities. And it is important that we know that it is not the instrument in terms of dealing with ownership and registration of interest. It is the record that the registrar makes that will determine the registration of the interest, the legal interest. And I think that is important. I also want to point to Clause 13, which is similar in dealing with lands. Now, Clause 10 deals with the first registration of land. Clause 10 deals with the first registration. That first registration, the most important part is the work of the registrar. And Clause 13 deals with any further dealings in the land. The important part is when the registrar creates a legal interest by making the notification in the folder. I think that several senators have spoken on Clause 14, and my note on that, it is vital. And as practitioners, as people who deal and interface with the state bureaucracy, the power of a bureaucrat to make small changes is a vital power. If they choose to exercise it, or if they exercise it in the public's interest, is a matter over which we in here have no control. But we do understand that even in every aspect, even in drafting legislation and publishing legislation, there are going to be typographical errors, there are going to be unintended errors, and you want to have a senior administrator with the power to make corrections. And That I consider to be an important inclusion, and I've heard several of my colleagues say they welcome it, and I'm happy to hear that. Madam President, the other clause which I consider to be extremely vital is in that clause dealing with the recognition of interest. Let me see if I could get to it. Dealing with the difference between interests that are obvious on the folio and the need to also, as I mentioned at the start, look at things which are not recorded on the folio. Madam President, I heard a lot of discussion on section clause 20, which deals with this search, this power to do searches and all of that. I want to say, Madam President, I mean, you just have to Google land fraud in Trinidad, and you will see. The Law Association has, in fact, put out information on land fraud. There are practitioners who have expressed concern about land fraud. I can tell you, Madam President, as a minister, I have referred matters to the fraud squad, and I have referred matters elsewhere, and it deals with fraud. And it is not something that should be taken lightly. I can tell you from experience, and any conveyancer or solicitor will tell you that the history of what we call the Red House is replete with cases where people go in to the search room and take a razor blade and cut out deeds from the books. And that is simply because in the torrent system or the RPO system, all you need to see is the certificate of title. As my friend Senator Hussain said, it works on the mirror principle. And whatever is in the registry is recorded or should be recorded on your duplicate certificate of title. And that is a simple way of ensuring that you know all the transactions on your title. In the deed system, for example, if you're doing a transaction in Rio Claro, you will physically have to go to the registry for the Rio Claro books or the county books, because, you know, as we've evolved, we've kept to some of the older terminology. You'll have to go to the Nariva Mayaro books. You may have to go to the county Ward of Kokal books in the Red House. And what you're looking for, you have to go through book by book, deed by deed, to see if there was any dealings in this land. The only way is if you come across a deed. So if, for example, somebody acquired the title by virtue of a deed of conveyance from January 1970, and there is a transaction in 75 where that parcel of land was sold, and that deed is cut out of the book and removed, then some nation.
Minister, you have 5 more minutes.
Thank you. That the access, there may be hurdles or there may be preconditions to access. But I think on this one, I think lawyers who have practiced conveyancing in this country will welcome anything that protects those historic records once we have a system of conveyance of title in this country that relies on those historic records, and we do not convert fully to a system by which you can look at one document and establish a historic record. And Madam President, it's not too hard to find an analogy. For example, in motor vehicle transactions, you will get a certified copy which shows you the chain of ownership of the vehicle. But registration in this country is not compulsory. Registration of ownership is not compulsory. You are not required to have an entry. You have people who do transactions without recording the transaction. And that is one case in which you'll have a registered owner of a vehicle and you'll have an equitable owner, that is the person who have paid for the particular chattel. So it's not unusual. And the reliability of the physical records is the mischief that Section 20 aims to deal with. Madam President, I want to close just by pointing to two areas which I consider again to be important because of the way in which I believe it affects legal rights. Clause 23, I don't think anybody has pointed to that, but it makes an important change in the deletion of the words is guilty of and the substitution of the word commit, and that is something that for when we get to the other bills we may see that also. That is a very important change. And finally, this of course is a necessary, clause 22 is a necessary amendment, but I could see administratively that it could be complicated to administer, because what we are doing here is that we are not completely repealing the RPO. We are not completely repealing the ordinance. We are repealing, but recognizing that there would have been other places in which aspects of that legislation have been saved, and we are not interfering with that. So this is not a complete repeal of the RPO. This is a repeal, except where parts of the RPO have been saved elsewhere. And it is very important that that is preserved, because under the laws as they currently exist, we have rights accruing that we do not want to interfere with a brand new piece of legislation that affects people's rights. Madam President, I am very hopeful today that we are headed in the right direction. I will close by saying what I always say: this falls in the hands of bureaucrats, technocrats, public servants. They are the ones to bring this to life and to change the lives of those individuals like Marva Mendoza and the deceased Leo Joseph in how they enjoy property rights and they are able to access certainty of title. And I look forward to having full support for this bill brought by the Attorney General. Thank you.
Good afternoon, and thank you for the opportunity to contribute on an act to amend the Registration of Titles Act 2000. And I want to begin, Madam President, by indicating that I didn't plan to speak at this particular venture, but I always like to come after the Honorable Minister of Agriculture, because he always gives a very unique perspective in his contribution about any matter that we are debating here. And today he began his contribution by giving us the humanitarian side of how this legislation will affect persons in many different ways. And he gave us the example of Leo Joseph and Marva Mendoza, who, when you hear stories like that, you understand how the kind of impact that what we do here as a Senate has on the people of Trinidad and Tobago. But I want to give another side of that story. And just as the Honorable Senator read the letters that he had in his possession, I have a number of letters in my possession too that I want to read, that are a bit on to demonstrate the way land is enjoyed in Trinidad and Tobago. My learned friend, the Honorable Minister of Agriculture, told us about how long Leo Joseph and Marva Mendoza had to suffer, for want of a better word, in order to get what they were rightfully entitled to by virtue of the NHA first and the HDC and the institutions that came after. But let me give you another example, Madam President, and let Trinidad and Tobago know about the other way in which land is enjoyed in this country. I want to read into the record of the Hansard a letter dated the 7th of August, 2017, and it's very important for us to just like the Honourable Minister pointed to the length of time, I also want to concentrate on the length of time. On the 7th of August, 2017, somebody by the name, a citizen of this country by the name of Alana Haynes Patrolman, wrote to the Commissioner of State Lands, Roosevelt Place, number 1 to 2 Jatan Lane, El Socorro Road, San Juan, Trinidad. And it's a very short letter, and I want to read it slowly so the population can hear it. Dear Madam, I am seeking your help with an ongoing emergency that I have encountered. on the 31st of July 2017, where I reside at LP number 53 Bottle Alley off Lady Young Road, Morvar. My door was broken down by my relative, who is the owner of land, which my house resides upon, and all my personal possessions were removed and placed in the front yard of the building. I wasn't served with any eviction notice. He have since, that is the writing, so I'm quoting, he have since been denying me access by locking his gate until I get a truck to collect my items. I am currently homeless and have nowhere to house my items. I am kindly begging for your assistance in getting a parcel of land to house myself, family, and items. Respectfully yours, Alana Haynes. That is the 7th of August, 2017. 7th of August. We just heard a story about some people who are suffering for over 40 years to get the entitlement. On the 15th of September, that is 1 month and 1 week after, under a Ministry of Agriculture, I don't want to use it as an instrument to demonstrate, under a Ministry of Agriculture, Lands and Fisheries, Land Management Division, Commissioner of State Lands, 1 month and 1 week after, Ms. Alana Haynes, unlike Leo Joseph and Marva Mendoza, got a response to her request for land. This division wishes to acknowledge receipt of your letter dated 7th of August 2017, in which a request was made for the use of a parcel of state land due to an emergency. I'm not going to read through all of it because I have a limited amount of time. Please be advised that the Commissioner of State's Lands, well, it says Stata Lands, has given careful consideration to your request contained in your letter referred to above and is prepared to grant you a license to occupy state lands at lot number 115 5 Rivers Aruka as a temporary relief for residential purposes. The Commissioner of State Lands, as a condition of your license, you are hereby advised that no permanent materials are to be used in the construction of any structure to be built on the site, which must be used solely as a residence for you and your immediate family. And I'm going to stop there, Madam President. Madam President, I have a bundle of letters here. I put them away. That ought properly, as the Attorney General has said, we are here to give support for doing the right thing, to discharge our duty in the public interest. And therefore, whenever wrongdoing is discovered by whoever it is doing, it must be brought to the attention of the authorities and they must act on it. And it cannot be. We are here to debate the registration of titles. The Attorney General made it very clear in piloting this piece of legislation that one of the aims of this legislation is to fight corruption. Corruption comes in all kinds of different forms. And if a citizen of this country can write to a public servant vested with the authority under the State Lands Act to administer all of the state lands that belong to the people and the citizens of Trinidad and Tobago, and without any procurement, without any search, without any research, no cabinet approval, no ministerial approval, you can take state land and give it away willy-nilly like that. I hope that when we all act in the public interest, those who have committed these kinds of acts are brought to justice, if only so that people like, referred to by Minister Rambrat, like Leo Joseph and Marva Mendoza, don't have to be put on the other side. That is one side of it. But this is a bundle of documents referring to one particular individual holding the highest office in this country for the administration of state lands. And this is what is going on. Giving away the state land, like if she has the fee simple in it, and Trinidad and Tobago's fee simple belongs to that one person. So I hope that that is one aspect of it that we will get into. Madam President, I think that no one can properly understand the remit of what we are involved in here unless you refer to Section 2 of the Principal Act, which this is a unique piece of legislation that actually sets out what the aim of the legislation is in Section 2. And I think for completeness and for Trinidad and Tobago, I think I should be able to read into the record what the purpose of not only the amendments, because the amendments join with in achieving these purposes. And the purpose of this act by virtue of Section 2 of the 2000 Act is to A, provide certainty of ownership of interest in land and to simplify proof of ownership, facilitate the economic and efficient execution of transactions with respect to interest in land. C, provide compensation for persons who sustain loss in circumstances prescribed. And in order to establish these purposes, which are very laudable, there are a number of things that are referred to in subsection 3, which I will not go into in detail. But, Madam President, the Attorney General took us back to 1066, which is the Norman Conquest. And Minister Rambrat referred to two significant pieces of English legislation, which is Lord Kane's Act of 1858 and the Supreme Court of Judicature Act of 1873, that we must all understand when we treat with pieces of legislation like this, that we inherited as an English crown colony the land law that formed the law of the United Kingdom. And it is that that has shaped the way in which we have administered the registration of land. And in that historical context, one must understand that, as the Attorney General indicated, we are an island state, and land is perhaps the most valuable resource to all of us. And in so doing, part of that historical context is that on the 15th of June, 1215, what we all celebrate today as Magna Carta was principally established because of the administration in which King John, in 800 years ago plus, was administering the land in the United Kingdom as it is today. And the barons were not prepared to accept the way in which that land was being administered in the feudal regime in 800 years ago. And that led to the removal of King John shortly after, I think it was 2 months after the signing of Magna Carta. But, Madam President, this act that we are debating today, the amendments that the Attorney General proposes, are aimed at making better the system that we have. And the Attorney General spent some time in explaining, in piloting the legislation, that we have registered land, which is known as the Real Property Ordinance, and we inherited that from the Australian system, as the Attorney General made reference to, which is commonly referred to as the Torrens system. And then we have unregistered land, which those who are involved in transactions we call old law land, where you physically have to go and do the searches. And what we are seeking to do by these amendments is to really tighten up, because the Attorney General has said that this system has been in place for over 100 years, and there are certain weaknesses in the system that have exposed themselves over the period of time, and we need to change them. And the Attorney General has set out what the aims of the legislation are. In piloting the bill, we were told that there are over 250,000 squatters in this country who are going to be affected by the fact that we are going to implement a system whereby we hope to achieve a single registered system of land where all interests that people hold in land will be in one place and can be accessed at one time in one system. And the Attorney General was very specific in saying that it is a piecemeal process that we are going to engage in. We heard that the government has been able to access $100 million US from the IDB, and I'm happy to hear that, and $7 million to do the administration. But one has to understand the background, Madam President, to pieces of legislation like this. And while the Attorney General has said again in this debate that we have had a long period of analysis paralysis and we must bring it to an end and we must move forward, we must also be careful that we move forward in the right direction and with the right approach so that we will get the right result. And why I say that is because while the Attorney General was specific in pointing out that with this loan that has been given,
a little too frequent in the chamber. Whose ever device just went off, I would ask you to leave the chamber. Leave the chamber, stay outside for about 10 minutes, sort yourself out, talk to whoever you have to talk to, call whoever you have to talk to, and come back in. So whoever that device belonged to, please leave the chamber now for 10 minutes. Continue, Senator Ramdeen.
Thank you, Madam President. Madam President, I was on the point of the way in which we move forward. And I would like to suggest to the Attorney General that while the process is going to be engaged, whereby the government is going to engage a process, the Attorney General make reference to Tobago and Trinidad, when one understands the way in which interests in land, proprietary interests in land, are created over time, those 250,000 squatters that we have in this country, some of them are what I call real squatters, and some of them are the beneficiaries of the certificate of title, a creation of another piece of legislation, the state land regularization, sorry, certificates of comfort, I apologize, a creature that was created under the State Land Regularization Tenure Act, Chapter 5705. We have to understand that occupation is something that happens over time. And included in these 250,000 people will be people who have been in possession for less than 16 years, more than 16 years, and over 30 years. And the reason why I use those terms, they're very significant, because 16 years is the period of time in which in private land you eclipse the title of the owner by virtue of possession. 30 years is the period of time within which you eclipse the title of the state in relation to land that is deemed to be state land under the control of the Commissioner of State Land vested in the President. And before 16 years, you have periods of time within which people hold an interest, and I say interest in inverted commas, Madam President, but they are unable to register that interest. And what is important about that is that when one comes to the definition section, which is one of the sections that we seek to amend, this is Section 3 of the Act, land is defined under that definition section as missuages, tenants, hereditaments, corporeal and incorporeal of every kind of description, or any estate therein, together with all parts, passages, ways, watercourses, liberties, privileges, easements, plantations, gardens, mines, minerals, and quarries, and all trees and timber thereon, or thereunder, lying or being. And while the Honorable Minister of Agriculture made the point that a lot of things that cannot be registered now, this piece of legislation will be able to cure that defect, and it is a laudable one. What is missing from that definition is that someone who is in possession of land for less than 16 years is unable to register that interest because it is not a title and it does not fall within the definition section. And I would suggest to the Attorney General, as I did informally to him, that in order to really give teeth to this legislation and to capture the 250,000 or a large majority of the 250,000 persons, what the English legislature did in 1925 by the suite of legislation that they passed in 1925, which we didn't follow, was that it allowed someone to have an interest in land, like a possessory title. We say possessory title, but being in possession doesn't give you any title. What it does is that it eclipses the title of the registered owner. This piece of legislation, unfortunately, as it presently stands, will not be able to give someone who is in actual possession of land the right to register that interest, that so-called interest, I would say, that they have. And I would ask the Attorney General to carefully consider that, and to, if we wish to really achieve the aims of this legislation, to be able to put into the legislation a definition that will capture that group of people and give them the ability to register. And why that is important, Madam Registrar, is because as... Madam President, I'm sorry. I apologize. So caught up in this. Madam President, why that is important is because the Minister of Agriculture and the Attorney General referred to the fact that a very important aspect of this legislation is the characteristic of the indefeasibility of title that comes out of the Torrent system and is incorporated into this system. And as the Minister of Agriculture described in his contribution, even in RPO title, where you are going to register an interest by a memorial endorsed on the back of the certificate of title, that will not allow the person who is searching the title to know what is actually on the ground on that particular piece or parcel of land. Because there are many instances where the indefeasibility of title by persons who think that they have an indefeasible title, when someone purchases based on the back of the memorial of the RPO, purchases the land, they find that when they actually go on the ground, there are persons there who have actually eclipsed the title, and they are allowed to eclipse the title because of the limitation periods that are put into different pieces of legislation. And therefore, you have circumstances where a legitimate bona fide purchaser for value purchases a parcel of land based on the memorial on the back of the RPO, and then finds that he has to seek some type of compensation from the compensation fund, because what he purchased is actually not what he's entitled to, and it is no fault of the person who is the vendor. So, Madam Registrar, that is a very important aspect of the registration of title that, one has to consider. And Madam Registrar, Madam President, I apologize. Madam President, the fact that what we are concerning ourselves with this afternoon is this piece of legislation that is going to definitely modernize the system for the registration of land. And I just want to piggyback again on the example given by the Honorable Minister of Agriculture. I can speak about it because the matter has now come to a close and it's not sub judice anymore. But we recently had a situation in this country where persons who were not able to register their occupation because of the absence of certain clauses that are similar to what we are seeking to put in today have suffered great hardship. Because while the opposition supported this legislation in the other place, and subject to the changes that we will suggest, we intend to, in the public interest, do what is right to modernize this system. It cannot be right, Madam Registrar, that a year ago, army officers, police officers, drove up with their armed vans and vehicles and bulldozers and backhoe and went into a place called Pine Avenue in Sandy Grande and demolished over 50 homes of people who were on parcels of land. There is no mechanism for them to register their entitlement. They were on state lands and their homes were demolished by the same administration who brings legislation that tells the country this is the way to go. And while one understands that a critical part of this legislation is the provisions that deal with condominiums, well, that is at one end of the scale, Madam President. We also want to ensure that the legislation that deals with condominiums in Bayshore and West Moorings and Chaguanas and Maraval also deals with the people who live at Windsor Park who are squatting, and the people living at Pine Avenue, and all of those thousands of people who also want to register their interest in land. It may well be in the government's interest to deal with the condominiums, because one understands why. But we should not, by the passage of this piece of legislation and the opportunity that we have to improve the system, not take an all-embracing approach and be able to provide some type of relief for those people, Madam President. And Madam President, just to go on from that point and to develop that, in doing what we seek to do by modernizing the system of registration, land law in our country has changed over time. And one understands the position of the Attorney General saying, well, we can't have more analysis paralysis. And we've been doing this for some period of time. But there are two issues that arise out of that. The first is that the way in which someone acquires adverse possession pursuant to a piece of legislation that we will debate after, but materially affects what you can register under this piece of legislation that we are debating now, has changed over time. And it started off with the old Latin saying of nec clam, nec vi, nec precario. And that was then transformed into a system where the law as it stood was that someone who wished to acquire adverse possession had to dispossess the title owner. And then that changed, and the law, as expounded by Lord Brown Wilkinson in Pye and Oxford versus Graham, that was in 2002, was that you no longer needed to have the intention to dispossess. All you had to do was to have the intention to possess. And therefore, it is those changes over time that we as practitioners have to maneuver for our clients in relation to understanding how you can acquire an interest that you can register under this said piece of legislation. That brings me to the next point, which is this. If the Attorney General says we have 250,000 squatters in this country, how are these 250,000 squatters to understand what they must do and how they must treat with their possession in order to come to a position where, as the legislation proposes under, I think it's section 15, that they can register their title? And what is important, Attorney General, is that, yes, we must stop the analysis paralysis, but we must also be able to educate all of those persons who are affected by the passage of a piece of legislation like this, so that they themselves will be able to assist the government. Because like with the property tax legislation, and the government has to go out there and get the property tax forms for over 400 or 800,000 persons, 450,000 people who have properties. It is a similar exercise that has to be done in getting the registration of titles up to date. And unfortunately, I have been involved in litigation where you can't trace title, and you have to go and get aerial photographs that are very, very limited in the Lands and Surveys Department. And unfortunately, we had one person in this country, Mr. Paul Williams, who was a photogeometric engineer, that used to actually, out of his own pocket, pay an airplane to fly around Trinidad over periods of time and to capture in photogeometric form the possession of every single parcel of land in Trinidad and Tobago. And that is what we use at the end of the day to establish whether people fraudulently are acquiring land or not. And one of the things that this legislation proposes, Madam President, by the insertion of the amendment to Section 23, and also by the amendments that are proposed by Clause 29, is to tighten the way in which this registration takes place. But before we get to that, there are a number of persons, and the Attorney General and perhaps the Minister of Agriculture will know this as well, there are a number of persons who have a profession in going to court with RPO applications for lands that they have not occupied for the requisite period of time to allow them to give them that prescriptive title. They go, all they have to do is survey the parcel of land. You can get that done by just paying a surveyor to do it. You get 3 people to go on affidavit and say you've been there for 30 years. And you go before the court, you advertise, and if you do that, you acquire title to that parcel of land, which is protected by the indefeasibility provisions under Section 141 and 142 of the Real Property Ordinance. And while we want to concentrate on the fact that we are moving forward, there is a lot of work to be done in clearing up the fraud that exists in the system already. And the Attorney General, in the limited time that he had, sought to explain that under the old law system, Madam President, as it stands now, somebody could convey the red house. They could convey the waterfront, and it will be registered. And they could take that, and people don't quite understand the consequences of it. But they can take that deed and then go and take bail for somebody, right? Which is how the system is manipulated and what it is we are trying to cut out. And the Attorney General says that this is all part of a package of legislation that is supposed to fight the scourge of corruption. And that was voiced as well by the Minister of Agriculture. But you know, the unfortunate thing about that, Madam President, is this. The last comment of the Minister of Agriculture was that we must all understand that this falls within the hands of public servants to administer at the end of the day. And when one thinks about when one reports a fraud to the fraud squad, when it takes 10 years to investigate and the people have died and the documents are lost, the system becomes so innately corrupt that it is very difficult to see the effects of the passage of a piece of legislation like this on the real corruption that goes on in the system. And to not go, of course, Madam President, but if I can go straight to the provisions of the Act itself, I would like to suggest to the Attorney General that while Senator Mark made the issue about the qualifications, when one goes to Section 6, and we are amending that section by Section 6, subsection 3, I'd like to humbly suggest to the Attorney General that in addition to putting in the post of a Senior Assistant Registrar in subsection 3 to subsection 6, the qualifications that are set out there, which I think is the point that Senator Mark was making, and a point that the Attorney General directed Senator Mark to subsection 6, section 6 of the principal legislation. It says, no person shall be appointed as registrar unless he's an attorney at law of at least 7 years' experience in land law. Well, respectfully, while we in colloquial terms might understand what land law is, law dealing with land, I guess, it's not a term of legal art. And one would understand that if you say dealing with land law, it might be somebody teaching a tutorial in land law at the Hewitt Law School. It might be somebody who now and then deals with land. But, I mean, we really need to tighten this, because these are people, like I made the suggestion at the very outset, maybe, who are being given the power to interfere with people's titles to land. It is perhaps, apart from liberty, the most guarded possession by the citizens of Trinidad and Tobago. And I would humbly suggest to the Attorney General that we probably define land law as being perhaps in conveyancing or in transactions that deal with the sale of land or the registration of land, instead of just leaving it as wide as it is. I think it will only do better to get the more qualified people to occupy that post. And in subsection 6, subsection 3, the one that we are amending, it says no person shall be appointed as a senior assistant registrar or an assistant registrar unless he's an attorney at law. Attorney General, I think we should put a little bit of qualifications there, because we understand, I think you and I, the people who are involved in the system understand, an attorney at law who is qualified from the Hewitt Law School, respectfully to all attorneys at law qualified, they have very little practical knowledge about how the system works. And despite the best training in conveyancing and land law at the Hewitt Law School and at wherever institution that they may get their LLB from, it really doesn't make them qualified to be able to adjudicate and to administer something as important as this piece of legislation. So I'll humbly suggest that we just tighten that. The substantive pieces of law that we are asked to look at today, Madam President, I want to deal with clause 29. And that particular clause seeks, the amendments to section 29 seeks to do a number of different things. And I think it forms itself into the new clause 31, subsections A to D. And what this seeks to do is to give the registrar the power to rectify the register or any instrument presented for registration in the following cases. And Attorney General, may I direct your attention to B and C and D of your new clause 30, where it allows the registrar by subclause B, 31B, to rectify the registrar in any case at any time with the consent of all persons interested. While one understands that you might have to rectify title, and therefore this is really like a deed of rectification power that one is vesting in the registrar to exercise ex proprio motu, the difference, or what I want to suggest, Attorney General, is that you might have a situation like this, where you have two parties who are the parties to the memorial, again, affecting a parcel of land. But on the ground, there may be other persons who may then subsequently find out that while the legitimate de facto parties to the conveyance would be allowing the registrar to have the power by just informing these persons, we may well do better in the legislation if we give an opportunity in this section that to give notice when this is done, so that anyone who is affected but whose name is not on the register will have an opportunity, whether it be in 14 days or 28 days. Their interest may be affected, and they can apply to the registrar to either rectify or re-rectify, if you want to use those words, or to at least treat with what interest they may have that may be affected by the consent of the two de facto parties to the transaction. So that is one way I think we can improve that. The other section I would like to suggest to the Attorney General that we can amend to tighten the legislation is in subsection D. And the experience from practitioners, from a practitioner's point of view, Madam President, is that on a very frequent basis, unfortunately, in the court, you have situations where the Registrar General is made a party to proceedings, especially where you have applications to set aside an RPO title, and one needs the order of the court to interfere with the title that is already registered on the RPO register. And what you have is that you will have determinations of the court that would then give directions to the Registrar General to rectify the title or to cancel a certificate of title. But there is no actual requirement of a period of time within which it is to be done. So you have cases where the private parties can go for contempt, or they can go to enforce the order. But I think we will do well if we put in a provision that places a duty upon the Registrar General to be able to do this within a particular period of time. It will help those people. You see, Attorney General, a very practical, sorry, Madam President, a very practical way of understanding why that is important is this. You have a situation where someone goes to court to set aside an RPO title. The court delivers decision on the 1st of the month. Before, what the court does by that decision is say the title is set aside and give a direction for the certificate of title to be cancelled. Before that is effected by virtue of compliance with the court order, the person with the registered title goes and sells to a bona fide purchaser for value, having the protection of the indefeasibility of title under 141 and 142, and therefore they commit it allows, the system itself inherently allows you to commit a fraud on an innocent bona fide purchaser for value, because the decision of the court, which is what you are targeting here, has not been effected within that period of time. And therefore, I think it is important, it will do well for the legislation, for us to put that in there. I don't know if it is possible that by virtue of the Supreme Court Adjudication Act, we can place a duty, you might be able to do it in here, a duty on the registrar where there is any order of the court that affects.
Senator Ramdeen, you have 5 more minutes.
Wow. All right, thank you, Madam President. To inform, it is usually done, for example, where a fraud is committed, that you would have a direction by the court to send the order of the court to the Director of Public Prosecution and the Commissioner of Police. And there is no reason why we can't put in a section that places a duty upon the court or the Registrar of the Supreme Court to inform the Registrar General in any case, because as you know, Attorney General, when the matters are filed, the court knows exactly if it's a setting aside, a RP, or whatever it is. And once there is a duty placed, we can effect that protection to be able to make better that system. Madam President, there is one other section that I want to quickly treat with, which is the amendments to Section 73. And there is a particular time provision that is dealt with in subsection 4 and subsection 5 that deals with the suspension period, which is really the period of time for which one can lodge a caveat, and you can have persons with opposing interests lodge their interests during that time. I've tried to study this section carefully, and the first thing that jumped out is the fact that I think the period of time for the suspension is quite short, because how it operates as presently drafted, Attorney General, is that the suspension is automatically lifted within 14 days without the intervention of anyone. And therefore, if you have a system as we currently have, where in 14 days you don't get a deed registered, and perhaps a caveat is not registered even in that period of time, you can run into the unfortunate circumstance of someone having an opposing title or an interest in land opposed to how you describe it here as the principal instrument. And during the period for the suspension, which is the period of time within which people can come forward, it can defeat the purposes of the legislation because the time period is too short. The suspension is expired, and one is able to register immediately thereafter. And therefore, I would ask the Attorney General to carefully look at those subsections. I propose to treat with them in the committee stage. Principally, Madam Registrar, this piece of legislation is a piece of legislation. So Madam President, this is a piece of legislation that I think we all agree is needed to modernize the system of land registration. But one has to be, as I indicated at the very outset, understand that in order for us to reach the point that we want to reach with the registration of titles of land. There are many persons that are affected with varying interests that can be registered under this piece of legislation. I want to emphasize that education is a very important element of the passage of any piece of legislation like this. And if it hasn't been done before, it is not too late on the passage of the legislation, whether before it is assented or after the regulations are put in, for the government, through the Office of the Attorney General or the Ministry of Legal Affairs, to undertake an education program in the very rural communities. It is more important to do it in the rural communities by qualified persons, so that persons who do not have access to the internet, persons who do not understand what their interest is, people who are sitting on their rights for a number of years, and also persons who can be affected by persons who are in possession of different parcels of land can also do that. We have large estates in this country with persons who have been occupying lands for a number of years, and they have no way in which they can gain relief to provide them with the security that they are entitled to, as the example given by the Minister of Agriculture. And therefore, I look forward to seeing that the implementation and the rolling out of this piece of legislation will provide for those things so that the entire population of Trinidad and Tobago will benefit at the end of the day. I thank you, Madam President.
Leader of Government Business.
Thank you very much, Madam President. I rise to make a brief intervention in this debate on the suite of land bills before us, starting with the Registration of Titles and Land Act, which will be followed by the other three, hopefully during the course of this afternoon, this evening, and into tonight. Let me start by congratulating the Attorney General for his foresight and his vision in bringing these pieces of legislation before this Honorable House, especially during this period where we all know there is a serious crime situation in the country that we have to tackle. And we have been focusing on a suite of crime bills. We have been focusing on a suite of financial bills coming out of the Minister of Finance, bills to improve the judicial process. And all, I think, compliments to the Attorney General and the Minister of Finance. But in the general legal architecture of Trinidad and Tobago, a lot of emphasis is placed on the DPP's office and the Solicitor General's office. But the unsung hero in this whole architecture to me sometimes is the Registrar General. Because there's a lot of issues that is handled by the Office of the Registrar General, and in particular land management. So I want to congratulate the Attorney General. I will only make a brief intervention and deal with two specific aspects of this bill which I want to contribute into. The background has been outlined in the bill essentials here. Starting in 1978, where the Law Commission undertook a program of reform aimed at modernizing the legislative framework. We went on to debating these various bills in 2000. And just like the DNA, it took 17 years before it was proclaimed. Why the inertia in this country for so long? Here we have back-to-back examples of issues of inertia that has suffocated Trinidad under various administrations. And I think that as a country, we have to wake up, smell the coffee, and understand that we have to progress forward. So in that context, I really want to congratulate the Attorney General in bringing these bills before us. Well, let me make some general philosophical points. In a modern democracy, one of the most fundamental basic human rights is the right to own property. And Madam President, through you, I think Senator Ramlin said outside of the right of security, it is probably the most fundamental rights available. Because for some strange reason, the human species likes property. And if you study human anthropology, though it is rooted in human anthropology, you know. It's called the territorial instinct, where even the dogs have it. The dogs urinate across their boundaries, you know. And they say a dog bad in his own yard. When he comes out, and he knows where his yard is. The right of property is ingrained in the human psyche. We all know, you know what chopping in this country took place over boundaries? And in the country, it doesn't say my boundary, it say my bong. Don't cross my bong. And plenty cutlass pass over the years based on 1 foot of land as to where the fence is or where the fence isn't. I just want to relay an experience I had in Texas some years ago when I used to be a geologist, I think.
Always a geologist.
We used to go to this annual conference of AAPG, American Association of Petroleum Geologists. And we'll normally have a field trip after the conference. And you will traverse riverbeds and looking at rocks and what have you. And one day this field trip was headed by a professor from the University of Texas at Austin. And then while we were on the ranch, a Dodge Ram pulled up, and a rancher took out his shotgun and said, "Get out of my property." Through you, Madam President, when a Texas rancher pulls a gun at you and say, "Get out of my property," you might as well, very well, listen to him and get out of his property, because he will shoot. And I'm serious, he will shoot you. Because property rights is so fundamental to the American, especially down south, in states like Texas and Arizona, that it tells you how fundamental this aspect of it is. I just want to share one more experience before I go on to the 2 clauses I want to speak about. Land has always been the subject of revolution. You know. Land tenure has been the basis of most of the Latin American revolutions. Am I right, Senator Chris? Madam President, through you, let me just share a lovely experience with this House. One of the high points I consider of my political career is when Nelson Mandela came to Trinidad. The Prime Minister, Mr. Manning, at the time, asked me to accompany him when he had to speak at the Center of Excellence. He was staying at the Hilton. So there I was, with the great Nelson Mandela, 2 of us alone sitting down in the back seat of a car, driven by the army. And for half an hour, we had a one-on-one conversation. Few people in the world had had that privilege. I don't speak about it much. And I asked him, not much question because he was old, why didn't you go the way of Robert Mugabe and seize the lands that were taken away from your people? And his answer to me was, son, you struggle your entire life to help your people. But at the end of the day, when they get up in the morning, if they do not have a job to go to, and the children do not have a school to attend, you have done nothing. He said it will take 3 generations to regularize South Africa. But it is the way I had to go. I couldn't go the way of Mugabe. Lo and behold, to tell you how fundamental this land issue is, the young Turks of the African National Congress now is revolting. You know why? Because of land tenure. And they want the land situation rectified in South Africa. because it is so fundamental to the human being and so fundamental to the concept of land that it is intrinsic in the human species, that you do not play the fool. So I don't know if that's parliamentary, but you do not mix matters when it comes to issues of land. So with those introductory remarks, Madam President, and I said I will be brief, I just want to deal with two aspects of this bill. And to talk about what I'm reading out here from the bill essential. Further, a proprietor or potential purchaser is assured that what is endorsed on the land certificate is indefeasible, and the need to worry about hidden defects capable of defeating title is significantly reduced. That, to me, is where a lot of the racket used to take place. Because I know of instances where if you have the money to buy the land cash, you go to an attorney, good attorney. They search the title, they say it is free of all encumbrances, and they're willing to proceed with the transaction. Lo and behold, that same parcel of land, if you go to the bank, and the bank have a cadre of high-powered attorneys, they will find defects in the title, you know. And you will be surprised to know what minor defects they see. And sometimes it stops you from getting a mortgage from the bank. And the bank's attorneys, I don't want to call them by name, but it's a particular group of attorneys. I say that without apology. So this indefeasibility of that will give the Registrar General that power. To me, it is a substantial move in the protection of the people's interests. The other aspect is the issue of the Registrar General having the powers in formal matters, and in the case of errors or omissions, not materially affecting the interests of any of the proprietor. I've seen too many occasions where issues that are not material to the title has stopped the transfer of land, the probate of a will. I know of one particular example that I was involved in. I can't call too much names here. But on the probate of the will, the person's name was Joanne, Joanne, and the surname. In another document, it marked Jo-Ann. And the lawyers took the position that they ensure that this Joanne is the same as the other Joanne. Obviously, the name was just one document had it with a hyphen, the other document had it without a hyphen. Yeah. In a case like that, under this new pieces of legislation, the Registrar General could adjudicate. Right. Yeah. She or she will now have the power to say that is a minor defect, if it is a defect at all. So that is a very, very good part of this law. Most of the other speakers would have covered a lot of the legal aspects of this matter. The other final point I want to deal with, Madam President, is Clause 10 amends Section 14 of the Act to clarify that it is the entry of a memorial in the folio endorsed by the signature of the register that give legal effect to first registration and not the signature on or registration of an instrumental document as the law now currently provides. The whole concept of first registration, I think it was dealt by the Attorney General that relates to Tobago lands. And I think the people of Tobago now seeing the light at the end of the tunnel to have their land issues rectified. But today I speak in my former position, portfolio of Member of Parliament for Ottawa Mayaro, which included Moruga. And this same concept will apply to the Americans. The people who formed the companies of Trinidad, first company, second company, fifth company, sixth company, because they were descendants of African slaves who fought for the British in the American War of Independence. When the British lost the American War, they came by companies and they settled in the Moruga area. Most of them know it is their land. They have passed it down for generations, but none of them has a deed. None of them have a certificate of title. In fact, my favorite village in Moruga is a place called Douglas City in Fifth Company. And Douglas City means Douglas City. It was the result of a mixed marriage with, and actually the mixed marriage produced 12 offsprings. I mean, I really love going there because it just tells you what Trinidad could be. So 12 Douglas got 12 parcels of land from the master pass. The 12 Douglas half married to Africans and half married to Indians. So you have almost pure Indians and pure Africans who are first cousins. Yeah. And they all live in one community. It's about a 20-acre parcel of land. Everybody has their lot and their plot. It was distributed to them over the generations. It's a P&M nest, if I should say so myself. But it personifies what life could be in Trinidad if we behave ourselves. So, ladies and gentlemen, through you, Madam President, this first registration concept will help the people of Douglas City, help the people of Fifth Company, will help the people of Sixth Company, help the people of Mason Hall, will help the people of Plymouth, will help the people of Calder Hall. So, again, it is good legislation. It is to the benefit of the citizens of Trinidad and Tobago. It gives you the right to own property. Fee simple is the word they use. Free of all encumbrances. It makes the system less cumbersome. It makes the system more user-friendly. It makes the system more affable to the national population, to the citizens of Trinidad and Tobago. Again, why this legislation has taken so long to come before us? As the saying goes, all's well that ends well, and I'm sure this piece of legislation will end well here this afternoon as we unanimously pass this bill and the other subsequently 4 bills. With those few words, Madam President, I thank you.
Senator Hayes.
Thank you, Madam President. Thank you for the opportunity thank you for recognizing me to contribute on this debate on an act to amend the registration of titles to Land Act 2000. I do believe that all the speakers who've gone thus far on the opposition bench have already noted that the purpose of the act and the amendments are indeed quite laudable and something that, in principle, we want to support. And because the idea, and as everyone who has spoken noted, of certainty in ownership of land is something that is culturally critical to our citizens. And I mean, globally, but in Trinidad and Tobago in particular, there is a penchant for ownership and looking at who owns the property. And I think that is what Senator Khan was alluding to when he was talking about the boundaries. I would just like to take the opportunity before I go into the clauses of the bill to just address one point that I've heard raised, in particular by the Minister of Trade, which is that the bills, when the minister was speaking, the minister spoke about the importance and the revolutionary aspect and the groundbreaking nature of the bill and the land reform package in totality, which, again, we all agree with. But then the minister questioned, well, why didn't we take it all together? So my question is, if it's so important and so critical, then I think we should be afforded the time to go through each piece of legislation one by one. So I think we are agreeing, but there may be a difference in the approaches. And it's not, I think, it may be put forward as a delaying tactic, but more importantly as a way to say, yes, we agree that this package is important and it is essential and it will touch and affect the lives of many people in this country. So therefore, let's do it the right way and make sure we get it done properly, and that we show our commitment to the people of Trinidad and Tobago and putting forward the best work, because we cannot on one hand lament the work ethic of persons outside and say, you know, we need to improve the work ethic, and then in here say, well, let's just try and get things done all in one shot. So I also thought the contribution by Senator Rambrat was rather informative, and the story of Leo Joseph and Marva Mendoza, I think, is one that I've heard time and time again and that I've seen myself. And while I reflected on this, on the legislation before us, all the pieces of legislation, I said to myself, what would be the impact of the legislation once we get done with our business here on the lives of the people of Trinidad and Tobago? And in theory, it would be extremely impactful and it would be revolutionary, as we've all said. However, unless we work on the implementing agencies, and I know the Attorney General said that in his wind-up he would give some of the details and add some flesh to the arguments, but unless we work on the implementing agencies, would we have effectively done anything here rather than just pass the legislation and hope for the best? And I just, Senator Rambrat, in reading the letter, Rambrat, in reading the letter from Mr. Leo Joseph and Maria Mendoza, noted that they had to go to several different agencies and had letters from several different people. And I had in my notes before, you know, why do we have so many land-related agencies and institutions scattered all over the country? So while we're saying in the legislation and it's listed right here in Clause 2 of the Parent Act, that this act is to facilitate an efficient execution of transactions. So while we're trying to get this part right with legislation, we're ignoring the fact that the Registrar General is under the Ministry of the Attorney General and Legal Affairs. There's a Land Management Division and Survey, and the Survey and Mapping Division in the Ministry of Agriculture, Land and Fisheries. There's Town and Country Planning Division of the Ministry of Planning and Development. The Ministry of Trade deals with some issues for building, constructions, and permits. There's the HTC, the Land Settlement Agency. Some of the 14 corporations deal with land issues. All of these people hold manual records, and there's different information about the same parcel of land held in ministries scattered throughout the government. And so as you reflect on the story of Leo Joseph and Maria Mendoza, once we get through this exercise, will we really be helping them? Or is this same system going to obtain? Because have we looked at the implementing agencies of the Commissioner of State Lands, the Registrar General, the Conveyancing Department, and they're all under immense pressure And so we bring in the new system, and we pass the law. Are we in any way thinking about how the legislation will actually go forward and be implemented? And I thought Senator Rambarat's story, Minister Rambarat's story again, it just speaks to, we do one thing inside the parliament, and I think Senator Ramke soon raised it as well, and outside of the parliament, what we desired and what we hoped to see happen is not what obtains. And so I'd like to just take a minute and look at the role of the Registrar General's Department, just really quickly. And it's responsible for the registration of all civil, land, and company records, and it is the sole custodian of these records. And the department has been at the registration house in South Key since 1999. And prior to that, it was located in the Red House. And we have a situation where we're modernizing the land laws, and we're all in agreement with this. But are we modernizing the institutions that have to implement these laws? And, you know, you've had stories about strikes within these, where workers are dissatisfied with their arrangements, their working arrangements. And, you know, I think the department, and it was supposed to move to the government campus plaza, and I'm not sure, you know, if in his wind-up, when the Attorney General starts to deal with, again, the flesh around the bones of this legislation, because while the foundation is important, and yes, while it is important for us to get started and to start somewhere, it is also important for us to know, or for the public actually, to know that this is not an exercise of us just saying we've done something and we check the box and then we leave it. If it's meant to do something, well, let us do it correctly, and let us give the citizens a fighting chance, so that when you go to engage in with these institutions, that you have an opportunity to really reap the benefits of the legislation. And so I just wanted to look at some of the implementing agencies, but not to run afoul of the standing orders. I do have one, and I'm not saying the Attorney General in the chamber, but I do have one proposed amendment. So to just get to the gist of it, in the Parent Act, the Clause 11 talks about the registrar who, by authority in writing given to officers at the land registry, required that the authority be exercised in accordance with the general or specific. So that the registrar may look at the deputy registrar, the senior assistant registrar, etc., and delegate duties in writing, by authority in writing. And the Clause 14, of the amendment amends Section 30 of the Parent Act. And it says that the registrar may rectify the register or any instrument presented for registration in the following cases. And the Attorney General explained in his opening remarks about why this clause was rectifying a major defect, in that it allowed for flexibility so that you aren't crowding out the system or making the system unnecessarily cumbersome. But my concern is with Section 31, Part B, which reads, the amendment reads, in any case, at any time, with the consent of all persons interested, so that the registrar, and if by virtue of Section 11, anyone that he or she may designate in writing, give the authority to in writing, may rectify the register or any instrument presented for registration in the following cases. And what I was hoping is that, because we've all noted how important land ownership and how important this register is to us, and Senator Khan, Senator Ramdeen, Senator Ramrat all noted how easy the instances of fraud can take place, especially in relation to land issues. And we live in a country where I think, as most people noted, that not everyone is honest. And so that when you talk about, well, yes, but when you're talking about giving consent, I was hoping that the Attorney General will consider that we can put that the consent be in writing, because it's very easy, I think, where you've seen people come up with a story or concoct a situation where they've said that this has been granted or the land had been transferred, and you've had instances where elderly parents have been duped out of their property by even as people as close as their children. So I'm saying, and the Attorney General noted earlier on that the Section 29 was an anti-fraud device, and I'm saying it's a very simple consideration that we can just insert the word to give owners or to give persons who have property rights just that added comfort that you cannot just interfere with their ownership, and that changes cannot be made easily. Because while we do want a system that is efficient, we also want a system that protects the citizens and protects the rights of law-abiding citizens. So and so that was as I was going through the legislation, I thought that we can look towards that as a possible added protection. And the reason being that I said that we do support the legislation in principle and the principles of the legislation. And so as we move forward, I think that was the one amendment to one of the clauses that I had. But I do have the more general concerns of whether or not we can properly implement it and whether or not we're going to put enough meat into the implementing agencies and have to ensure that the proper competency and training will be held. So because when you're talking about, if you look at under the idea of institutes of training and competence, which arise in both the Registrar General Department and the Surveys and Mapping Unit, we have to talk about whether or not, as we modernize the system and as we look to move forward, we have a staffing complement that is capable of doing what the legislation is asking them to do. And so you're looking at what we can anticipate as a request for demarcations and surveys because of recent developments, including things like the property tax. And people will want to get their affairs in order. And so I'm asking if the system as it stands would allow for this swift move for modernization. And the Minister Ramrat went through the history of land registration in England and Wales, and I had also looked at this, and I looked at the timeline, which is quite extensive, and I think the Attorney General did note that this will take time. That as we move forward, we do have to start somewhere. And that it will take time for us to get there. But while we understand that, we can learn from our mistakes in previous cases where we would have passed laws and not been able to implement them because we did not. I think the analogy that he used, that while the grass is growing on the long term issues, there were short-term pastures so that while we are looking at the legislation as a long-term fix, there are simple, low-hanging, short-term fixes that we can do if we really took a holistic approach to this, and a holistic and sensible approach where you start with the agencies that are meant to implement the legislation and move forward.
I will ask the senator with the offending device to leave the chamber and return in 10 minutes, okay? Senator Haynes, as I invite you to continue your presentation, I just have to remind you that you're now going over, okay?
Yes.
All right.
Thank you, Madam President. And I would also, because my intervention here was also brief because I really wanted to raise the point of written consent. But I do want to stress again that the need to prove ownership of land has always been of great importance. And that you look back, I think, even to as far as the Neolithic era, the need to prove ownership, they found evidence there where what we thought were burial grounds were actually demarcation lines. So this is a critical and essential area. And because of how important it is, I think there is a very big need to get it right and for us to do all that we can. And so I urge the government to think about the amendments that the opposition bench will make, because it is meant to strengthen the legislation and it is meant to help it work for the citizens. And if we can all agree that is what we're here to do, then I believe that we can get through this in a manner that will show respect for the nation that we're meant to serve. And as they look on at us today, because a lot of people look on when we deal with land issues, because it is so important, that they will feel comforted that we've been doing their work. And I thank you.
Put your mic on so that I can see Senator Obika.
Thank you, Madam President. I wish to assure members that I would be as brief as is possible, as I seek to simply add to this debate. Basically, the bill, the core tenets of the bill has already been outlined, and I do not wish to go over that. And so I would move on to some main issues that I find that should arise. So if you look at Part 7, Section 65, 66, 68, etc., regarding the assurance fund, and I see in the Parent Act, it makes prescription for the assurance fund. Such fees received by the registrars may be prescribed, and reference is made to a negative resolution of Parliament. I want to ask the Honorable Attorney General if he didn't see it fit to bring in the actual amount that would be required when you look at the valuation of a mortgage, of a property, sorry, that would be required to be contributed to the assurance fund. I hope that the Attorney General could give some guidance as to that, because really and truly this will be a fiscal matter, as it would impact on the government's ability to effect aspects of the legislation regarding the repayments of persons aggrieved. And this is an important aspect of the bill. Some amendment was made to Part 7. However, no specific mention was made of, no change was made to impact upon the percentage of the assessed value that would require transfer to the assurance fund.
Senator Obika, I am so sorry, but I'm not sure I'm understanding the relevance of what you're saying. We have an amendment bill that deals with specific clauses in the Parent Act. So just point me to what you're talking about as we move along, please.
Thank you, Madam President. As I said earlier, Part 7, I guess it's my willingness to go so fast that probably caught persons off guard, and I apologize if that happened. But if you look at Part 7 of the Parent Act, there's a clause, the clause that deals with, that would be Clause 18. Basically, Clause 18 is the only clause that dealt with amendments to Part 7. So all I'm asking the Honorable Attorney General is to consider, or asking if consideration was given or if they are planning to introduce it in the committee stage of the bill, regarding the actual amount, percentage of the assessed value, for example, or the formula that will be used to make contributions to the assurance fund. So that's the first point I wanted to make. Given the importance of the assurance fund, as it really looks to rectify those unjustly deprived of their rights over real property by reason of the operation of the laws. Now, so that is that initial point, Madam President. Now, regarding a main issue that persons would have stressed on, for example, the Honorable Minister of Trade would have mentioned the importance of this legislation and the registration of titles for persons to access credit facilities and specifically mortgage facilities and mortgage lending. Now, a main aspect of acquiring a mortgage would require a process of evaluation and qualification. And if one needs to understand the mortgage facilitation procedure, a key aspect of that would be the deed of conveyance and also ensuring that the property is identified for purchase has a valid title regarding a deed and is free of encumbrances, as the Honorable Minister of Energy mentioned prior. Now, once we accept that, it will be important, Madam President, to inform the population as to why this is necessary and why this is important. Because there are many studies, and the literature basically points to a correlation or a causal relationship between land registration and economic development. And one article I want to point to, which basically would form essentially the second and final point of my contribution to this debate today, but albeit the second, I may need at least 10 minutes to wind it up, right? I want to point to an article titled The Effects of Land Registration on Financial Development and Economic Growth, a theoretical and conceptual framework by Frank Biamugisha. I would not attempt to repeat the surname. Now, basically, this is a document of the World Bank, all right? And they basically looked at establishing that direct relationship. And I want to read just the abstract, parts of the abstract for the record, Madam President. They're saying that this framework, in terms of land registration, is necessary to improve upon current and past investigation approaches, which are focused on one sector. So they're saying that it's important to understand that land registration affects every sector of the economy. And land tenure.
I just want to report which report he's taking that from.
Okay. Thank you. I will repeat it. The effects of land registration on financial development and economic growth, a theoretical and conceptual framework of the World Bank by Frank Biamugisha. The second time it's all better. Now, basically, there's a drawing, a diagrammatic that points to land registration, and I just want to run through an oral visual for persons. So it starts at land registration. I am one who takes correction, you know, so you can repeat it for my one of my vocations is storytelling. So now, one point I want to bring is this. In the World Bank's doing business report, in terms of registering property, the World Bank asserts that after registrations in some jurisdictions, property values increase. Okay? Now, and I just want to read a little bit of that. Evidence shows that owners with property registered titles are more likely to invest in the local economy. Furthermore, increase in land value and land efficiency is often observed. In Nicaragua, having a formal title not only made owners more likely to invest, but increased land values by 30%. Following a land titling project in Thailand, property increased in value by 75 to 197% after being registered. Now, there can be social fallouts from this. Therefore, the government would want, as a counterpart to this legislation, to look at supporting young professionals, as the Honorable Minister of Trade pointed to the challenges of young persons to access mortgages. We would want to assist young professionals in mortgage support, given most persons don't get contracts beyond 5 years, which aren't seen to be favorable to lending institutions, with the exception of the TTMF, but the private lending institutions, who would find it the risk to be beyond bank risk. All right? So that's that point, Madam President. The government should take note of that aspect. Another point I want to raise in this same issue regarding development and its relationship with land registration is that the steps for property purchase and transfer of title are a key aspect of this legislation, as it affects the collateral, which is used in business operations, which supports new loans. And of course, the property should be available for resale of the buyer. Now, Madam President, financial development is causally linked to land registration. Land registration enables the market to move more efficiently. It allows tenure and security. It improves the ability of persons to invest because it reduces information asymmetry. So therefore, the lenders can place more trust in the system, given that they can't be blindsided by new information or information that the other parties may have access to, and they not, given the inefficiencies in the system. So obviously, us on this side, we applaud any decision to correct wrongs in our society. All we are doing is ensuring that the procedure that is embarked upon really brings some form of restitution to persons who may be aggrieved. Now, a key aspect of financial development is the transformation of land into a liquid asset. And
I have given you leeway here. You have, even though you have spoken on issues that other members have spoken about already. But I think now you're stretching your presentation a little bit, and I need for you to focus on the matter at hand.
Thank you very much, Madam President. Now as I close my contribution, basically, I really, this opportunity, I see it as a teaching opportunity. So I apologize, but that is my background. But I will curtail the lesson, and I will reduce it to 2 points. Effectively, more land registered results in more borrowers, results in a wider access to credit. This legislation is essential to that. However, what the government needs to ensure occurs is that they provide the relevant institutional supports, and I want to point to my initial point regarding the assurance fund. If they can give some indication as to a timeline for the calculation of what value of the assured value of properties would be remitted to the assurance fund, what timeline they're going to come back to Parliament with this, given that it would be subject to a negative resolution. And I thank you very much, Madam President.
Senator Amin? All right. And Senator Amin, at this stage, honourable senators, we will suspend and we will return here at 5:30. So we're suspended until 5:30.